Thank you, everyone. Please be seated. We're here today for several different matters. State of Iowa versus Chad Staten is hereby submitted without oral argument. Brendeland versus Iowa Department of Transportation is also hereby submitted without oral argument. Our first oral argument today is the case of State versus Fenton. Looks like the parties are ready. Mr. Irwin, you may begin.
Thank you, Your Honor. May it please the court, counsel. Josh Irwin on behalf of Corey Fenton. Mr. Fenton's conviction for solicitation of commercial sexual activity should be vacated and the case remanded to the district court for dismissal because the evidence was insufficient to establish either of the namesake, if you will, elements of the offense. The evidence did not establish that any commercial sexual activity was involved in this case, and even if it did, the evidence established that any solicitation, that is, coercion, recruitment, or enticement, was flowing from the police officer to Mr. Fenton, not from Mr. Fenton to the police officer.
Oh, wait a minute.
Yes, Your Honor.
Friender, which I've never had social media, but I know what that means. He friended her. Isn't that true?
That's true.
And isn't he the one who first asked, can we hang out? So it's not all by the cop, is it?
No, so the solicitation has to be to engage in commercial sexual activity. It's not just...
When I start right off with, hey, want to have sex, it's going to build up, isn't it?
Yes, and it did. This conversation absolutely started fairly mild, became quite explicit over the course of things. But the important thing to keep in mind is that the enticement, recruitment, or coercion has to be to commit commercial sexual activity. And all discussions of commercial sexual activity, or at least things that the state argues constituted commercial sexual activity, were completely instigated and pursued by Detective Lowe, not Mr. Fenton. And I will turn to that in just a moment if I could spend a little bit of time talking about why none of this was even commercial sexual activity to begin with. I think this case is a good demonstration, in some ways somewhat similar to the Cole case, which was decided last term, of the state just taking a complete shotgun approach, not really being sure what it's prosecuting, and just throwing everything at the wall to see what sticks. So I think the most obvious demonstration of that fact is the state's argument first raised on appeal that the comment about making money or having money, I have money, what do you have, that constitutes commercial sexual activity. The state didn't ever even argue that at trial. And so I think that just evidences that the state, even here on appeal, is continuing to try and figure out just what it is that it's prosecuting here.
Exchange. I mean, I've read all of the text messages. Be candid, seems pretty thin, but this seems to be the strongest thing. I'm going to say NR, the Nevia, the police officer. What would you do for a threesome? What do I need to do? I don't know. Girls like food and clothes. Okay, I have no problem spoiling a little. That's what Mr. Fenton says. Then Fenton says, let me know what she says. Nevia says, okay, I will. And then Nevia says, you promise? And he says, yeah, for sure. So if the jury instruction is a promise of anything of value in exchange for sex, and here I suppose the proposition is a threesome with at least one underage girl, why isn't that sufficient evidence to support the conviction?
Needs to be enough to conclude that it was an actual legitimate offer of something in exchange for sex. I think it's important first, and I agree with you, of all of the things the state threw at the wall, that comes the closest, but it still isn't enough to constitute commercial sexual activity because, pardon me, within the context of this entire conversation, they were discussing sex acts. Flirtation is, I mean, it's distasteful flirtation, but I think it's just generally a flirtatious exchange.
But the fact that the detective initiates it, what would you do for a threesome? sort of asks, what would you, what compensation would you provide for a threesome? Does that make a difference that the detective initiates it and not Fenton?
On the solicitation element, if you would. But I think just, if I may finish answering that question, Justice McDonald, I'll address that as well, Your Honor. But there needs to be enough for a jury to reasonably conclude that this actually was an exchange, an offer of food and clothes in exchange for a sex act. And I realize, yes, Your Honor.
Like puffery, or you mean there has to be like some sort of bona fide offer of something? So if he would have said, I'll pay you $20 or whatever, you wouldn't contest that would be sufficient?
Exactly right, Your Honor. And it's, I realize in these interactions, and I said that in my briefing, people speak in code. Because this is criminal act, or it's a criminal offense, the offer and acceptance, if you would, aren't necessarily always as express as they would be required to be in a legal contract.
Well, inference that he is promising food or clothes? Could the jury draw that and connect those dots?
Exchange for sex. I mean, it's a reasonable inference that maybe he was willing to pamper in general if there would be a relationship. I know that's a problematic term under these circumstances as well.
That's what the other girl, in the broader context, would like, and he'd like to spoil her. That's pretty close to me to implying that he would gladly provide food or clothing in exchange for a threesome, right?
This comes certainly closer than any of the other things that the state argued, and certainly closer than the things that the Court of Appeals relied upon. But it's still not, I think it is more of a puffery sort of thing, as Justice McDonald alluded to. It's not a bona fide offer. It's not something that a threesome will only happen if you produce food and clothing.
Agree with me that 710.2a, the state has, that the only thing you're really arguing is the word commercial. Everything else, person shall not entice, coerce, or recruit, and I don't think you have any dispute on the law enforcement pretending to be under 18, to engage, let's take away the word commercial, to engage in a sexual activity. Do you think that statute is satisfied if the word commercial wasn't in there?
Yes, I think it could be. I think it is clear that Mr. Fenton was pursuing a sexual relationship with the fictional Nevaeh. But the problem is that's not illegal, or it wasn't at the time. They need this commercial component.
But if a guy wants to have sex with a girl and they're going back and forth on their communications, they're trying to line up when, where, is your mom going to be around, blah, blah, blah. That's obviously doesn't have a smidge of commercial activity. But you start throwing in things, bring stuff with you, food, clothing, whatever, even if he didn't bring it. How is that not a promise to give something in exchange to hook up?
I think within the context of the entire conversation, they talked about exchanging sexual acts. I will do this if you will do that. I just don't think this conversation rises above what I would characterize as distasteful flirtation. And obviously I know that very distasteful under the circumstances.
That word flirtation, but I think it goes well beyond flirtation.
Understood.
To what extent do we need to defer to the jury's determination on whether this was commercial or not?
Very little, frankly, Your Honor, because the way I think of sufficiency challenges is, should this have gone to the jury at all? And it shouldn't have, because there is no reasonable inference that this was commercial sexual activity or that it was enticement, recruitment, or coercion. And so, and that's exactly the problem in any case when the evidence is insufficient and it's sent to the jury, and particularly when the state just takes this complete shotgun approach. The danger is an innocent or a not guilty person will be convicted because we are handing this off to the jury and they can make mistakes. There's a point where it shouldn't go to the jury, and in my opinion, this should not have gone to the jury. Whether something is or is not commercial sexual activity, that's a legal term. Obviously, it's defined here, and it was defined in the instructions as well. But the first guardian against that, Your Honor, is the court. And the question is whether that legal term, if there's even substantial evidence for the jury to draw an inference that it's met. And in this case, it was not.
You're not raising any sort of, I guess, entrapment defense or claiming that there wasn't a solicitation or an attempt. You're really just challenging whether there was anything of value promised or whether this was commercial. Is that right?
So challenging the solicitation element. It is not precisely an entrapment defense, and I'm aware that's an affirmative defense that typically needs to be raised in the district court. But that's because the affirmative defense is admitting, yes, I did it. These elements are met, but the officer tricked me into doing it. This is different. These elements are not met because Mr. Fenton did not entice, coerce, or recruit. The police officer did. And so it's not an affirmative defense. It's that lack of the enticement, coercion, or recruitment element.
You acknowledged a moment ago, he probably enticed sexual activity. You're saying he didn't entice commercial sexual activity. Okay.
That is the offense at issue. It's not, and that's another error that the Court of Appeals made. The issue is not whether Mr. Fenton pursued sex with the fictional Nevaeh. It's whether he pursued commercial sexual activity with her, and the evidence is insufficient to conclude that. Particularly, I'll just point briefly to the other things the Court of Appeals relied on, the rental of a shower and the Uber. As I mentioned in my further review, if those things, if getting a place to have sex and arranging transportation to get there constitute commercial sexual activity, there is very widespread commercial sexual activity going on. Those are things that a married couple might do. That's just far, far, far too broad an interpretation of commercial sexual activity. There has to be an actual quid pro quo element, which is what there was a lot of fighting about in the trial court. The state insisted that is not an element.
Well, I'm looking at the definition of commercial sexual activity in 710A.1. Means any sex act or sexually explicit performance for which, is that where you think the quid pro quo comes in, for which anything of value is given?
Yes, Your Honor. So it has to be, yes, that's precisely right. That for which language demonstrates it's not just coincidental. It's not I bought a person something and then later we had sex and those two things were completely unrelated. The thing of value has to entice, has to be in exchange for sexual activity in this case. And there is just no evidence that any of these things were in exchange for sexual activity. There's no evidence that Nevaeh believed a shower rental was a thing of value or an Uber ride was a thing of value.
About the photo evidence that was challenged. One of the arguments was that it was needlessly cumulative, but your guy never ever acknowledged that it was him, and he also made it disappear within 5 seconds. What should we make of that?
Your Honor, I would disagree slightly. The person who sent it made it disappear within 5 seconds. So Mr. Fenton's arguments were, one, that it is not him, and two, that he did not send it. And neither of those points is established in any way by the photograph. There was no argument this photograph doesn't exist, and it was clear it does. The jury saw the recorded interview where the police confronted him with it. He denied sending it. The jury was made aware that this photograph was received by the officer. And this again goes to some of the errors made by the Court of Appeals. The Court of Appeals said this was probative to the fact that he used that disappearing messaging feature and the fact that the photograph was sent. It's by him.
Conversations, right, about the dirty talk. And the cop testified that the same line of communication, whatever Facebook account or whatever it was, I don't know how they were communicating, whatever account it was the same account that he received the nasty picture, right? So isn't it circumstantial evidence? And obviously the jury was persuaded, or the judge was, because it was a preliminary question about the picture. So if we assume that, yeah, he sent it, and what would that look like? What are we to make of the fact that it had the disappearing app attached to it? and that he's continuously denied it. That would not be cumulative, would it?
There was, to those points, it was cumulative to the officer's testimony. I received this photograph.
Think that if he says it, the jury shouldn't see it?
Not necessarily, Your Honor. It's a balancing question, right? It's not this. This is our potentially relevant evidence, and I understand relevant evidence comes before the jury, unless its probative value, in this case quite low for the reasons we've discussed, is outweighed by the danger of unfair prejudice, which is quite high.
It really was a 15-year-old girl, and she got that picture. Maybe he ends up being a really scary guy, and if it's a real situation, he's going to find her. That picture is I think very powerful, and I think for you to say that it was redundant or cumulative, I'm not buying that argument. I think it's very powerful, and just like a murder scene, I know defendants never want those pictures to be out there because it's so horrible. Isn't that kind of like this too? That was the act that he created. If we assume he did send that picture.
Time has expired. May I respond, please? It is powerful evidence of intent to engage in sexual activity. I wouldn't dispute that. That was well covered. That is why this was cumulative. They have 160 some odd pages of a very explicit sexual conversation. That element was well proven.
Went backwards and said, okay, I'm afraid defense counsel is going to argue this is cumulative, so I'm putting the picture in first. Boom. There's the picture.
It wouldn't make any difference, Your Honor. It's still any probative value. The defense still knows what evidence is going to come in. They know this conversation is going to come in. They know the officer is going to testify about the conversation. And so we're in the same position, whichever order the evidence comes in. Any probative value that photograph could offer is substantially outweighed by the danger of unfair prejudice. There may be probative value. It is low, and it's a relativity question, right? It's given the low probative value in this case, is it substantially outweighed by that danger? And it was. Thank you.
Siefert. Siefert, I got it right the first time. Sorry about that.
May it please the court, counsel. I want to start, I think, where Justice McDonald had pointed out what I think is the strongest version of the commercial sex activity that was offered. And I want to put that into context a little bit. So these communications began when Mr. Fenton reached out to what he believed was a 15-year-old on November 20th of 2021. During that same initial conversation, he said it would be cool to hang out now, but was rebuffed. On subsequent dates, November 22nd, November 29th, December 1st, December 2nd, December 4th, December 8th, December 12th, December 19th, December 21st, and December 27th, he asked in some version or another, can we hang out now? Will you come over? He's also asking to video chat, which obviously the detective can't follow through with because there is no actual 15-year-old girl. Mr. Fenton has become frustrated. This girl has kind of voiced that she is willing to engage in sex activities with him, but is saying, I can't, I'm with my family. I need to wait for my mom to leave. It's not a good time, I'm busy. It's at that point, on January 2nd, where he has the exchange that Justice McDonald talked about, where he's now additionally asking for a new sex act that has not been raised before. He brings up this 15-year-old friend that had been alluded to before, and asks if she would also be willing to come along. And at that point, this fictional Nevaeh gives what I would characterize as a qualified no. No, if we were going to do that, what would you give us? Convince me why I should do it. At which point he says, what do I need to do? She says she wants food and clothes. That's what girls like. He says, I have no problem spoiling you a little. And then she specifically asks, do you promise? And he says, yes.
Review of the facts that the food and clothes were offered after they had already agreed we're going to have sex. Now let's work out the details.
It's important, Chief, is she has said that she will do these things. She's also consistently refusing to make it concrete in any way. I think the closest she comes on December 21st, and this is at the appendix 92 and 94 of the exhibit appendix, she says that we can probably make it happen next month, meaning in January. And he's put out by that. He responds, oh, with an ellipses after it. And then she asks him, what's wrong? It's only 2 weeks away. And he says, well, that's too long. He's frustrated, and he's looking for a way to sweeten the pot so that he can make this happen.
I think, yeah, that's one interpretation. The other interpretation is that the police officer is kind of, continuing to string this out, hoping he will make a very clear offer that is very clearly in violation of the statute. So I just want to sort of establish a background point. Do you agree that just paying for the shower at the Flying J, or just paying for the Uber ride, the things that would facilitate the act but aren't in exchange for the act, that's not enough?
So my answer is going to be in two parts, so bear with me a little. First, I do not concede the point that those don't qualify. We argued it below. I think that should be enough. I will concede that a line that could be drawn is between kind of incidental payments, things of value.
Run into the problem like the high school senior and the high school junior. The high school senior, the guy says, hey, why don't we go to the park and, we can get away from our families there. Oh, the park has a $5 entrance fee. Don't worry, I'll pay for it. And now he's committed a Class D felony or whatever. So that's not the conduct we're talking about, is it?
Your Honor, I guess there my problem is kind of more a global problem. So the way 710A2A talks about it, that it's both enticing, coercing, recruiting, or an attempt to do those things to engage in the commercial sexual activity. I think it always goes together. So any individual thing, a shower at a truck stop, a quarter for a kid to go use a gumball machine, like whatever de minimis thing you can imagine, I think it's very easy to say that's not something of value that would entice someone, but in the right circumstances, it could be.
It was presented at trial that this was the right circumstances. Was she saying, I have needed a shower for days, I'm a homeless person? That would mean a lot to me. I didn't see anything like that in the record. I mean, just plain hooking up in a shower. Help me understand how that's commercial activity.
Again, Your Honor, I'm willing to concede that that is a line you could draw, and I think if that line is drawn in these circumstances with a obviously fictional 15-year-old who's living in a house, presumably with a working shower, the value of a truck stop shower is effectively zero or de minimis, right?
What troubles me, then I go and I read the state's closing argument, the rebuttal argument, just before the case is going to the jury, and the prosecutor is saying, Ms. Maffitt, that's the public defender who was representing the defendant below, talks about commercial activity as though the money has to go to NR, as though it has to go to the officer, but the law doesn't say that. The cashier at Flying J, she's a person. The Uber rider, that's a person. He's paying, he's accommodating, he's doing whatever it takes to get that sex. If we think the line should be drawn where you're conceding it could be drawn, then isn't that troubling how they pitch the case to the jury?
Don't think so. I think those are correct statements. I guess maybe I would suggest this. In your example of, say, a high schooler who just turned 18 and his girlfriend who's still 17, the statute applies to anyone under 18. If they're going to prom or on a date or whatever, and they already agree that they both want to have sex and he's going to pay for a hotel, that thing of value is not enticing or coercing anyone. It's just an incidental part of their consensual encounter. If, however, that 18-year-old boy gets a no, I don't want to, you can imagine any number of scenarios where he could say, what if I take you to the nicest hotel in Des Moines? What if we do this?
Of this case, I mean, NR, I'm just going to call her NR, the fictional NR, agrees early on at the outset that she wants to engage in sexual activity. They're just having problems about the logistics. So if you're right about this prom example and they've already agreed upon the sex act and then they're just debating about when and where, then what is the enticement? I mean, as far as he's concerned, she's already agreed to the sex act.
Again, I don't concede any of those. I agree that if you draw that line, that kind of incidental costs of having sex, buying condoms, whatever, that is just part of the sex itself. And of course, we're not arguing that receiving the sex is itself a value that flips back on the sex act, right? So if you decide that those kind of incidental expenses, sure. I don't think that would be an illogical place to come out. I think the problem is that
Lenity play here, or the way that we interpret the statute. It seems, if we take your fullest argument, essentially the statute criminalizes almost all consensual activity. So boy calls girl, they agree they want to have sex. She says, I don't have a car. He says, well, I'll give you a ride, which is this case. I'll pay for your Uber, whatever. Under the state's theory, the ride, the gas, the transportation is something of value that facilitates the sex act that otherwise wouldn't occur. So don't we have some obligation to construe this statute in a way that doesn't criminalize all consensual sex?
But it only criminalizes it insofar as a jury is willing to accept and believe that it was enticing or coercing. It's not just commercial sexual activity, any exchange of value. It's someone who is using that as a carrot, dangling it in front of a person who is otherwise not doing the thing.
That way. They said he facilitated the Uber ride, and that's sufficient to sustain the conviction. Or he facilitated the Flying J truck stop shower, and that's enough.
I'll push back. We don't know what the jury found, right? I mean, certainly the state was arguing that as one option, but, and I kind of differentiated what was being argued as different points. The closing argument raised the shower, the marijuana, the food, the clothes, and the Uber. It raised all those things. And even if you say the others are incidental or not good enough, that one exchange for the food and clothes should be enough. That is, what do you want for this? I want this. Do you promise to give it to me? Yes. That should be enough, even if you say that these other incidental costs are not.
The rebuttal, I agree in the initial closing argument. Then defense counsel gets up, and then, here's more of it. The money's not going to her. The code doesn't require it. This is not a prostitution charge. Something of value has to be promised or offered up to any person. That's the difference here. I mean, isn't that troubling?
I think that's correct. I think what's being said is payment doesn't have to go to Nevea. You can pay a sports team for tickets to get entry to a game she wants to see.
Come on. This reminds me of a song by Meatloaf. Men say all kinds of things, and so do women, to get what they want and have no intention of going through with it. But that's so different than actual commercial activity. Help me understand how that's not a date.
I want to be very clear. I'm not co-signing the idea that dating and relationships are transactional in that nature. I will say that I understand that maybe some people feel that way, that there's an implicit, I'm paying for dinner, what am I getting from it? Some people may feel that way. I think the difference in what the legislature has criminalized here is we don't want people under the age of 18 to be pressured into consenting to sexual activity they would not otherwise agree to based on promises of literally anything of value. They can either say yes.
A little bit in this promise exchange about food. Let's just say NR says, I'd like to engage in sex. He says, that's fine. I want to do that too. And then she says, but I'm hungry. You need to buy me dinner first. Is that in violation of the statute? And he says, I agree. I will buy you dinner first, and then we will have sex.
I think it's much closer. I can see obviously arguments both ways. I think the state would still argue that that is a no unless, that is a qualification on the acceptance. I'm only doing it if you do X. The state does not want people under the age of 18 being bought in that manner.
Defense counsel, and I was looking at the code section, and I asked him if he would agree with me that if we took out the word commercial that were there, the rest of it, so the enticing, coercing, recruiting, law enforcement agent, all that business, and even sexual activity, I think there's no doubt that was the effort by the defendant. So would you agree with me that we're hung up on the word commercial?
Correct, Chief Justice. And I think even more pointedly, in case it's kind of lurking in the background, it's not in the record. My understanding is the reason that it was charged this way rather than solicitation of a minor, enticement of a minor under 71010, is because at the time, which has since been changed, the statutory language for that offense did not include "or a law enforcement officer posing." That's the real difference between, I think, those two offenses.
Shoehorn in the statute? I mean, is it really? Maybe should the court have considered that motion before it ever went to trial? Help me understand why it wasn't a legal issue that should have been decided otherwise.
It's not shoehorning if he committed the offense. I mean, if the elements are met, then the offense was committed. They could have also, I think, with the current statutory language specifically charged it the other way. I think that is a little broader because under this court's cases, I think one of the examples that's used for the non-commercial sexual activity crime is, luring a kid to come help with a puppy or something. That's obviously not an exchange of something for value, but presumably that statute would also include offers of something for value. So I think in that circumstance, it could be charged either way. My time is running out. I guess real briefly, just to touch on the exhibit issue, I don't think it's cumulative. I think if an officer testifies that a person had a gun, you can still offer the gun into evidence. And here, even more problematically, I think, for Mr. Fenton, that photo was probably the least of his worries. Given the explicitness of this conversation, I think a jury was much less likely to be offended by that photo than everything else that was going on and the context it was placed within. So having said that, unless there are any further questions, the state would request that you affirm the decision of the Court of Appeals. Thank you.
Mr. Irwin.
Thank you, Your Honor. I want to begin with a pretty broad point, so I don't want to, it's more of a global issue, but opposing counsel made a point to say we don't know what the jury found. That's a problem in this state that has really embraced the concept of general verdicts, that we're not going to go deeper than that. And the state is prosecuting with this utter shotgun approach. That is a problem that we're standing here today and we don't know what the crime was. As I said, the state, I don't think, ever knew in particular what it was prosecuting in the first instance. It threw everything at the wall, and now here we are. We have no idea what Mr. Fenton was convicted for. That's not something to say is a good feature of this legal system. And the solution is
Discussion about drawing this line somewhere. How would you propose or help us draw a line if we were so inclined to do so that would cabin this offense to commercial activity versus just regular dating activity?
it just needs to be, I think there needs to be a focus on the exchange element. And I think the state's emphasis on the thing of value element is misplaced. That's not what we're talking about. I will acknowledge any of the things that the state argued are things of value. The problem is they weren't offered in exchange for a sex act. And so they're...
Your guy would have had to say, using either pot, pizza, shower, whatever the things are in this case, what are the magic words that your client, if he'd have said it, you think satisfy the statute?
you marijuana in exchange for a sex act.
Going to say exactly that the court cannot, or the jury can't just gather from the evidence, circumstantial evidence, that was implied?
So And I understand that, Your Honor. I understand that a lot of times it's not going to be quite such an express thing. Your Honor asked me for an obvious example, I thought. And so, yes, I agree that the exchange is not always going to be that express, but it still needs to be enough to reach a legitimate inference that is, I am offering something and expecting something back in exchange for. And none of the things the state is pointing to.
Food and clothes for sex. Is that enough of an exchange for the commercial element?
It comes certainly closer than anything else, but I still don't think so. When you have to,
He doesn't have to have it on him when he shows up. It can just be a promise as well. So even those words are enough? He wouldn't have to follow through with it?
if he shows up with food and clothes, is certainly better circumstantial evidence that it was an actual legitimate offer, yes. But I agree the crime is in the offer, in something like that, so yes. That said, I think, again, in the context of this entire conversation, the detective is offering to pay for these things at various points that the state is pointing to. The detective offered to pay for the shower. The detective offered to pay for an Uber ride. And I think that shows none of that was an actual quid pro quo, this for sex. There was never any understanding between the two of that. I want to emphasize that there was never anything like a no from the detective. Of course there wasn't. He has to keep Mr. Fenton on the hook, right? If he just says no and shuts it down, he can't keep fishing for this commercial sex activity element. So
I keep coming back to the statement, and it's the one that you have said that you think is the closest. What would you do for a threesome? What do I need to do? LOL. IDK, girls like food and clothes, LOL. Response, okay, I have no prob, spoiling a lil. Does the fact that when they were meeting it wasn't for a threesome matter? In other words, that the deal that they were offering the food and clothes for, at least that he was maybe offering the food and clothes for, wasn't the thing that he was actually meeting for?
necessarily, Your Honor, frankly, because as the Chief Justice and I were discussing, it's the offer. Like, it doesn't have to ultimately come to fruition. They don't ultimately have to have sex, and that's why, of course, this offense can cover a police officer posing as a minor. But again, it would certainly be stronger circumstantial evidence if that's what he's showing up to do, and he has food and clothes with him. He shows up empty-handed, broke. I mean, he has nothing to offer, and I'm not saying that is necessary, but it's strong circumstantial evidence that this was not a commercial transaction at any point.
Statute, how would you distinguish between these two fact patterns? Let's say you have a couple and they agree, or there's an offer of sex, and the other person says, but you have to get me dinner first. And in the second fact pattern is you have to pay me $20 first. Those seem like very different situations. So what in the statute or in the jury instruction would separate those two?
The requirement, so I agree, and that's the problem here, is that the sort of broad nature of this statute allows the state to potentially prosecute lots of things that feel odd as being prosecuted. I think the difference is the first, buy me dinner first, is more. It falls into this typical it's a date, it's a Meatloaf song or something. But when it is this express exchange, $20 for a sex act, sure, that's easy to prove. And I understand there's gray area between those things, and there needs to be for the reasons we've discussed. But I don't think any of the circumstances the state is pointing to here rise to that level of an exchange, let alone, and I would just close by emphasizing, all of that was driven by the police officer, not Mr. Fenton. Thank you.
Fenton is hereby submitted. We'll have a brief pause here while we prepare for the second argument, which is Avenarius versus State.